I'd like to go over the concept of legal theories in improper disclosure cases. This deals with a patient's ability to sue a healthcare facility or provider for releasing information basically without permission. Of course, we've discussed there may be times when we are required by law to release patient information and we don't have to have the patient's authorization or permission to do that. But if if information is released improperly, a patient must have grounds for a lawsuit if the patient is going to sue over that. So that's what we're going to talk about as far as the legal theories in improper disclosure cases. Now, healthcare providers and institutions can face both civil and criminal liability for release of information of health records that has not been authorized by the patient, or again pursuant to law, when the law requires us to do it without patient permission. Now, civil lawsuits are initiated by a private citizen who usually seeks an award of monetary damages. So when we're talking about release of information, it would be the patient who would sue, whether it's the healthcare provider or the facility. It would be a civil lawsuit, and usually the patient would be seeking damages, monetary reward for damages or harm that was caused to the patient because of release of information. But again, if anybody brings a lawsuit, there have to be grounds for the lawsuit. Now, statutory basis for liability. And remember again, liability just means responsibility. There are state statutes that may impose both criminal sanctions and civil liability on healthcare providers that disclose health information without authorization. And notice it says state statutes, and again, written laws that have been voted on by the individual state legislatures on the books that can impose both criminal sanctions, meaning they can be fined or fined by the government itself, or will define how much an entity would have to pay if they were sued by, I say sued, if they were sued and this lawsuit was successful by a private individual, which in this case would be the patient. Now, in some states, there are statutes on the books that pose penalties for release of particular types of information. And it can be, for example, there may be a law on the book in a particular state that talks about release of or improper disclosure of information in general as far as health information, but then it can also be very specific to include such things such as HIV status. That's a law. There's a law in Wisconsin that is specific to release of HIV status or improper release or telling someone about another's HIV status. Now, theories of liability, again, just think of these as grounds for a lawsuit. And again, someone cannot just sue, say, well, I'm unhappy about this, I don't like it. There has to be a legal theory to back that. You have to sue on grounds of, and we're going to talk about the of what the grounds are for releasing information or improper releasing of information. We're going to talk about defamation, invasion of privacy, and breach of confidentiality. And those are basically the three theories of liability, meaning the three different things for which a patient could sue for improper release of their protected health information. And defamation. To prevail in a suit for defamation, the patient must prove the following: that a false and defamatory statement was made about the patient, that it was published to a third party, that the fault was on the part of the publishing party, and there was some type of injury caused. Now, A communication, as far as definition here, is defamatory if it tends to harm the reputation of another as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. So with defamation, within that category there are two types of defamation. There's libel, which is, and it's not liable like we've been talking about liability, L-I-B-I-A-L-I-T-Y. This is L-I-B-E-L. That's the written form of defamation, and slander is the oral form of defamation. Now, a patient's chances of winning a defamation lawsuit against a provider are very small. Again, there have to be grounds for the lawsuit, and so if a patient sues on the grounds of defamation, then they could win, the patient could win, but the chances are very, very small. The reason being is because medical records are ordinarily the truth. Defamation is a false statement about someone that would hurt that individual. So that's the definition of defamation. It has to be a false statement that's made. And normally, medical records are true. Now, sometimes mistakes can be made in medical records, but for the most part, medical records are ordinarily true. So, an absolute defense against a civil suit for defamation is truth of the published statement. Now, what that means is that if a healthcare entity released information improperly from a patient's record, or it could be properly, but let's just assume that the healthcare organization was wrong, that it released information improperly from the patient's record, and the patient sued that healthcare organization for defamation. If the healthcare organization can prove that the information that was released was the truth, then the patient is not going to win on the grounds of defamation. So, the absolute defense for being sued for defamation is that it was the truth. And so even if the healthcare provider was wrong and improperly disclosed information, that if the patient sues for defamation, that patient has to prove that the information that was released was false information that injured the patient. An example of this, two physicians mailed a letter, it was a group practice, and mailed a letter to a patient containing the results of a recent physical exam. There was a statement in the letter that the patient had gonorrhea, and this was during his marriage, and this was a mistake. This was a false statement in the record. Now, the patient asked his wife to open the letter and to read it over the phone. So what had happened, he had called home, his wife said, I have a letter from your doctors here. He said, okay, then why don't you open it and read it to me. Well, needless to say, much marital discourse resulted from this. And if you think about this and think about what defamation is publishing false information about an individual that hurts that individual. Now, if you look at this, it says, well, this pretty much looks like it meets all that criteria because it was false information. That was a mistake on the record, and it injured the patient because the patient's wife found out. I don't know what the end of this story is, if they divorced or what the situation, but much marital discourse we can use our imagination on that. So the patient sued the physicians for defamation. Was the patient defamed? When you look at all of these different things that happened in this example. Now, with defamation, to answer that question, yes, it was a false statement, but was it published? If you think about it, The physicians sent a letter to the patient. They did not publish the information because a letter is intended for the one to whom it is addressed. And the patient gave the wife permission to look at it, so it was not published. So even though it was a false statement, and it did end up injuring the patient, that was not defamation because the physicians did not publish that information to a third party. That it was addressed specifically to the patient, and the patient is the one that basically opened up that can of worms by telling his wife to read the mail. And so even though it met all the criteria as far as being false, it did not meet the true definition of defamation because it was not published. Now, consent as a defense. If someone is suing for defamation, even in the absence of privilege, and there's something called patient-physician privilege, and those are state laws that will protect the patient from having his or her physician testify in court. Even if there is no physician-patient privilege, a provider will not be held liable for release of health information if the patient has consented to the release. Now that makes total sense. That if a patient signs a consent or an authorization, basically, for release of information, and we act on that and follow the patient's request, and we make sure that that authorization is valid, that the patient then can't come back and say, well, I'm suing you for releasing my information improperly. They can take it back. They can revoke an authorization, but only to the extent that action has not been taken. Any action that's already been taken, we can't take it back. And so that's why you'll see on most authorizations for release of information, say this information or this authorization can be revoked in writing, or it may say can be revoked verbally, to the extent that action has been taken, meaning what's happened has happened. And so a patient can come back and say, well, yeah, I consented to it, but I changed my mind. So a person who knowingly consents to the release of medical records is barred from bringing a defamation lawsuit when those records are subsequently released. Now, the next theory of liability, we said that we're going to talk about 3, is invasion of privacy. So this is the second legal theory under which a patient can sue for disclosure or improper disclosure of health information. Now, a claim for invasion of privacy will be successful only if the challenged publication is not a matter of legitimate public concern and would be highly offensive to a reasonable person. Now, if a patient consents to release of information, again, he or she cannot later successfully claim that the disclosure was an invasion of privacy. Just as we just talked, the patient can't do that with defamation either. Come back and say, well, you consented for me to release the information, and now you're saying that it's not okay. And so, again, the same holds true with invasion of privacy. If a patient consents to releasing the information, they will not successfully be able to sue because that information was disclosed. So it's very, very important to get a written authorization for release of information. It's not any more legal. An oral agreement is just as legally binding. It's just hard to prove. And so if we have that proof by that signed authorization by the patient that the patient did give permission, that's our protection in case the patient decides to sue us for releasing his or her information. Again, if verbal authorization is given, it should be documented in the record. And it can be documented just as a note in the record that permission was received from the patient on such and such a day. And then the circumstances as to why we just had a verbal authorization versus a written one. There may be a legitimate reason for that, but even if we don't have an authorization signed by the patient and the permission is done verbally, then we still need to document that in the record. Okay, photographs. And then, again, and this is in regard to invasion of privacy. Use of photographs in a medical record creates a potential for invasion of privacy actions or lawsuits based on the grounds of invasion of privacy. There are photographs that are taken, but we need permission to take photographs. There are certain circumstances, maybe when in its abuse situation or something like that, where photographs would be taken, maybe not even with the patient's consent. But photographs are taken commonly in healthcare, but we have to really treat them with the same with the same concern as we do any other information in the health record. And so with photographs, you'll notice when you look at health records, if there are photographs in there, there will normally be a consent for taking those photographs, that the patient has actually given permission to be photographed. Now, as far as the examples, I know some examples are given about an individual who went to the plastic surgeon, and that's very, very common for before and after pictures to be taken when someone has any type of cosmetic surgery. And so an individual who was successful in suing actually did give permission for the physician to take pictures. But the example that's given says this individual was walking through the department store and saw herself as a before and after picture for some cosmetics that had been developed by a physician. And so that most definitely could be conceived or could be thought to be invasion of someone's privacy. It was not done for the medical treatment. It was done for personal financial gains on part of the physician. And so those are just examples of certain things that could happen. Also, there are examples of using photographs and taking them without the patient's consent, and that can also in itself be considered an invasion of privacy if photographs of the patient are taken and the patient's not told that they will be photographed and they do not give their permission to be photographed. Now, in addition to improper disclosure or release of information outside the facility, there can also possibly be an invasion of privacy within the facility. Monitoring of phone calls, allowing non-medical personnel to witness medical procedures or examinations. And you think, well, when would they do that? But it is a common practice that non-medical personnel, such as vendors who sell particular medical equipment and surgical equipment, a lot of times those vendors are the ones that train the physicians in the use of that equipment. It's essential for the physicians to be trained. And so sometimes the vendor will actually be in the operating room and, showing the surgeon or assisting the surgeon or at least observing the surgeon when the surgeon's learning how to use particular equipment. And so that's considered non-medical personnel. And the main thing here is to obtain patient permission for anybody who is outside the medical personnel category to be in the operating room or just a routine examination. And you'll see that at a lot of facilities, at teaching facilities, you have a lot of individuals who are learning on the job, basically. And so there should be permission from the patient for these individuals to be involved in observing treatment and learning by the patient's case, watching the attending physician or, again, non-medical personnel witnessing this type of, any type of procedure or examination. So again, teaching hospitals should get consent for house staff to make rounds, etc. Because if you've ever been to a teaching hospital as a patient or if you've ever worked at one, you know that when the attending physician comes in, there's usually probably about 4 or 5 other medical, or it's like called a house staff, but I say that it could be a resident, interns, medical students, those, and you'll have a whole group, a whole line come in. And again, they're learning, and that's why they're at that teaching hospital. But again, it could be construed as an invasion of privacy if the patient does not give permission for the house staff to make rounds. Okay, another area of concern as far as invasion of privacy is disclosure to the news media. Now, this is the most likely situation in which questions of invasion of privacy would be created. Usually, patient admission, discharge, or births are normally would not be considered an invasion of privacy, but to publicize the fact that someone had given birth to a baby that was conceived through artificial insemination might be actionable. Used to, it was very, very commonplace for the admissions and discharges and births to be announced, put in the hometown papers, and nobody thought anything about it. Now with HIPAA, again, HIPAA's come along, which would require permission to do this. Where used to, the hospital didn't get permission. It was just normally what was done. And most people wanted an announcement of the birth of the baby to be in the newspaper. But also, in some small towns, you would hear people on the radio, on the morning radio station, saying, "Well, so and so was admitted to the hospital today," and so that was common practice. But with HIPAA, it's curtailed that, and the patient, can deny permission for anything as far as their admission or discharges or anything to be publicized. But again, most of the time that would not be considered an invasion of privacy, just a normal declaration or publicizing of just a regular admission. But the example that's given, but to publicize the fact that someone had given birth to a baby that was conceived through artificial insemination, that may be considered invasion of privacy. Now, the third and final theory of liability as far as improper disclosure of patient information is known as breach of confidentiality, and also known as breach of physician-patient privilege. The assumption that if you go to the physician or any healthcare professional, that individual is going to keep your health information confidential is commonly considered a right of going to see a physician. And in most states, and again, I've mentioned this before, many states have a law on the books to allow for physician-patient privilege, or the confidentiality between the physician and the patient. It is a right that covers the patient. It's not there to protect the physician. But if the physician were to breach that confidentiality in regard to physician-patient privilege, that's another theory or another basis for a lawsuit. So breach of confidentiality. We've had defamation, number one. Number two was invasion of privacy. And number three, breach of confidentiality. And those are the three areas or legal theories or grounds for lawsuits for improper disclosure of patient information.